authority to bind the principle in the contract. Number 11, we will discuss the doctrine of respondeat superior. Number 6, fiduciary duty of the agent. Obligate the fiduciary to the principal. Number 7, we will discuss the duties of principals to the agent. Number 8, two methods that is used to terminate the agent's relationship. Number 9, principal's liability to the agent or to the third party. Introduction. In this chapter, we will learn the definition of agent relationship, categories of agent relationship, sources of law that governs the agent relationship. We will also learn the liabilities, the duties, and obligations that are created by the agent relationship. Definition of agent relationship. Agent is everywhere. Agent is defined as a two-party relationship in which one party, agent, is authorized to act on behalf of another party, principal, and one party, the agent, is authorized to act under the control of another party, principal. All employees are agents, but not all agents are employees. The sources of agent law. The agent law is existed in the state, each state statutory level with the branding of the state common law, and agency law is based on the former Restatement of Agents, 2nd edition. Classification of agent. There are 3 big categories of agent. Employee agent, independent contract agent, and gratuitous agent. There are 3 types of agent. First type of agent is employee agent. The individual employees who are authorized to transact the business on behalf of the employer principal are called employee agent. The principals are liable for all the action of employee agent, and principals are liable for the omission such as negligence of employee agent. Okay? It means that if employee committed wrongdoing, that employee's wrongdoing is directly transferred to the employer principals. Second type of agent is an independent contract agent. Independent contract agents are not considered the employee. Why? Because they have no legal protections of employees, such as minimum wage and overtime compensation law. Third type of agent is a gratuitous agent. Gratuitous agent is an agent who acts on behalf of a principal without receiving any compensations. That agent is referred as gratuitous agent. Employee agent versus independent contract agent. Direction and control. The criteria is used as a direction and control. The agent is classified applying substance of a form analysis based on the amount of direction and control that the principal has over the agent in terms of setting a work schedule, pay rate, day-to-day supervisions. Generally, anyone who performs the services for the principal is considered as an employee if the principal can control what will be done and how it will be done. That is referred as an employee. But independent of contract means that if principal has a right to control or direct only the result of independent work, and the principal has not the means and method of accomplishing the result, in that cases, that agent is referred considered as an independent contract. Okay, remember the difference between employee agent and independent contract agent. The criteria identifying the employee and independent contract used by the court are as follows. The California courts consider the following 8 criteria in order to identify whether he or she is an employee or independent contract. Please read these 8 criteria used by the California court in your home. Okay? Read the textbook. Okay? In your home. Also, the Internal Revenue Services has devised a 3-prong test to determine whether he or she is an employee agent or independent contract agent. 3-prong test is used by IRS. The IRS consider the first prong, behavioral aspect of the agent. Second prong is the financial arrangement between principal and agent. Third prong test is a type of working relationship the party had in terms of benefit and promises of continuing employment. If employer promised to continue employment, that is considered as employee. Not promise of continuing employment, that is referred as an independent contractor. Creation of agent relationship. The agent is described as a fiduciary relationship. Fiduciary relationship. Agent is a fiduciary of another person. Fiduciary of another person. Agents is defined as a fiduciary relationship that result from the manifestations of a concept that result from the both parties' consent by principal to the agent to act on the principal's behalf under the principal's control. That is a definition and creation of agent relationship. Liability of principal for the act of the agent. One of the most important aspects of agent law involves the understanding the ways in which the action of the agent. The agent wrongdoing is directly resulted in the liability for the principal. Agent, employees, wrongdoing is directly transfer the liability for the employer principal. That is the liability of a principal for the act of the agent. Therefore, when a third party customer claims that the principal is liable, employer is liable for an employee agent act, the client or customer is asserting that the employer is responsible for any legal consequences of employees' act. Agent's authority, agent's power. An agent has a power, authority to bind his principal only when the agent has authority to do so, to do something under the control of the principal, under the direction of the principal. There are two forms of agent's authority: actual authority and apparent authority. There are two types of agent's authority: actual authority, apparent authority. There are two main forms. Actual authority has two types of authority: expressed authority, implied authority. Actual authority is either expressed or implied. Express authority is created by the principal's actual word. There are two types of actual word: written word or oral word. Example: I want to hire you as my real estate broker, real estate agent to sell my house. This example is a this is an example of the oral word. Some men orally promise to other persons. In their cases, express